All rise. The International Court of Justice is now in session. The judges are now entering the courtroom. The case before the court is the case concerning the COVID-18 pandemic. The parties are applicant, the United Republic of Aprapluia, versus respondent, the Democratic State of Ranovstayo. The applicant and the respondent are each allocated 45 minutes to present their pleadings. The president of the tribunal will invite applicant to begin momentarily.
Well, good day to everyone. I hope you're all ready, in which case I would invite the first agent for the applicant to address the court, please.
Your Excellencies, am I audible?
Yes, indeed.
Thank you.
Right.
Mr. President, Your Excellencies, may it please the court. My name is Bei Jia Wei, and together with my co-agent, Ms. Rebecca Liu, we appear for the applicant, the United Republic of Aprapluia. We will each speak for 21 minutes and reserve 3 minutes for rebuttal. Your Excellencies, there are 4 issues before this court. First, can Ranovstayo impose a statewide entry prohibition on Aprapluia when Aprapluia had fewer than 10 COVID-18 cases confined to 1 laboratory in 1 province that was under lockdown? Second, can Ranovstayo persist in harboring Ms. Formund within its consulate when she was charged with 3 domestic crimes? And third, can Ranovstayo insist that this court has jurisdiction over its counterclaim when it concerns matters excluded by Aprapluia's reservation? And fourth, can Aprapluia be held liable for downing an aircraft that posed a terror threat to its capital city? I will speak on the first 2 issues, my co-agent on the third and fourth issues. Turning then to the first submission, we make 2 arguments. 1, Ranovstayo violated international law by imposing its entry regulation on Aprapluia. And 2, it is consequently liable to compensate for the resulting economic losses. And Your Excellencies, when we recognize that every state has the sovereign right to implement its own health measures, this right is not unfettered. In this regard, Article 43, Paragraph 1 of the International Health Regulations provides that a state's health measures, which go beyond WHO recommendations, must not be more restrictive of international traffic than reasonably available alternatives that would achieve the appropriate level of health protection. And here we submit that under Section 1 of Ranovstayo's entry regulation, at paragraph 10 of the facts, its statewide entry restriction against Aprapluia was excessively restrictive of international traffic and therefore in violation of Article 43, Paragraph 1 of the International Health Regulations. And this is because, Your Excellencies, there were several less restrictive alternatives that Ranovstayo could have adopted, which would have achieved its appropriate level of health protection, which was to minimize the risk of entry and spread of COVID-18 in Ranovstayo. And Your Excellencies, chiefly, we submit that Ranovstayo could have imposed its entry restriction to only Segura province, where the only cases were detected. And this would in fact be consistent with the practice of states in the COVID-19 pandemic, where countries such as Japan, Singapore, the Philippines, and New Zealand had placed province-level entry restrictions in the... Yes, Your Excellency.
Thank you, Agent. I would like to pose a question. You have presupposed, I think, that the international health regulations are binding. Could you give your authority for that proposition? And could you also deal with my second question, which is how much do you feel that looking at the situation under the COVID-19 regulations imposed by countries is relevant on what happened in the facts of this case, because this case, I would think there is no debate, occurred some period of time before the COVID-19 problem was identified. Thank you.
Your Excellency, I will address your two questions in turn. First, we submit that the status of the IHR is that it is binding on all states parties, pursuant to Article 22 of the WHO Constitution, which states that regulations adopted by the World Health Assembly shall come into force for all members. And here we know from paragraph 54 of the facts that both Apapluia and Rana Style are parties to the WHO Constitution, and therefore the IHR is binding between the two parties. As for Your Excellency's second question regarding the practice of COVID-19 in the current pandemic, if I understand Your Excellency correctly, you might be concerned about the intertemporal law doctrine articulated in the Island of Palmer's arbitration case by Judge Max Huber. However, Your Excellencies, we would like to switch this court that we are not relying on COVID-19 state practice to evince a new customary norm, but simply as subsequent state practice under Article 31(3)(b) of the VCLT. And these are obligations that states, yes, Your Excellency. I'm afraid I can't hear you, Your Excellency.
Sorry, is that better?
Yes, I can hear you now.
Yes. Doesn't that require agreement of all the parties to the treaty for subsequent practice to be relevant under Article 31(3)(b) to agree? Don't all the parties to the treaty have to agree in respect of that subsequent practice?
Your Excellency, not necessarily. Subsequent practice regarding COVID-19 is relevant under Article 31(3)(b) based on the actions that states have adopted with regard to the COVID-19 pandemic. And given that there are 196 states parties to the IHR, we submit that in our submission, these actions would show what states thought and interpreted their obligations to be under the IHR. And therefore, we submit that to that extent, the practice of states in COVID-19 is relevant. And state practice tells us that states in the initial stages of COVID-19 placed province-level entry restrictions, for instance, on northern Italy and North Gyeongsang in South Korea. And therefore, it is our submission that a reasonably available alternative here would have been to impose the entry restriction on only Segura province, where the only cases were detected. And further, Your Excellencies, this is because right after the first two cases were confirmed, Apapluia isolated these individuals and all of their potential contacts with immediate effect, halted operations at the National Laboratory, and even placed the whole of Segura province on lockdown on its own volition.
Were the first two individuals who contracted the virus, their contacts were isolated, but the later individuals who contracted the virus, there's no evidence about their contacts having been isolated. And isn't there a risk that, in fact, the virus will have escaped essentially by the time additional measures were taken?
Your Excellency, indeed we acknowledge that the facts at paragraph 27 only relate to the potential context of the first few confirmed cases. However, Your Excellencies, we also note that the whole of Segura province was placed on lockdown, and therefore any other potential cases would have been confined within the borders of Segura province, which was locked down on Apapluia's own volition. And therefore we submit that in truth, this virus was relatively isolated, and therefore a statewide entry prohibition was not justified and in violation of Article 43(1) of the IHR. And further, yes, Mr. President.
Isn't it rather difficult to argue based on the provinces of one country and comparing them with another country, because the factual situation is very different? Do you have any better argument than this possible lockdown of a single province?
Your Excellency, if this court is not convinced regarding the first alternative, we do have a second alternative. And this would have been to extend run-of-style's quarantine measures to all persons entering from Aprilia. And this, we submit, was an alternative that run-of-style clearly deemed viable, having implemented it for its own nationals at Section 2 of its regulation. And Your Excellencies, we further submit that because run-of-style only prohibited non-nationals from entering the territory, that not only violates Article 43.1, but also falls afoul of Article 42 of the IHR. Yes, Your Excellency.
The appropriate level of health protection is really a question of the amount of risk, isn't it, that a state's prepared to accept. And if you expand the number of people entering a country, even in quarantine circumstances, doesn't that increase the risk of the virus escaping quarantine arrangements? And so you won't meet the appropriate level of health protection because you have effectively increased the risk.
Your Excellency, perhaps the risk would be increased if all persons were to enter from Aprilia. However, we submit this would still be within the remit of run-of-style's appropriate level of health protection, given that this was not that of an extremely high or conservative level, but that of merely minimizing the risk of entry and spread of JVID-18 in run-of-style. This is clear from Section 2 of its regulation, where it allowed its own nationals to enter even from high-risk countries.
Can I interrupt you on that point? You make a lot of the fact that it allows its own nationals to enter, but states are required to allow their own nationals to come home. I don't see, or could you explain why it's discriminatory to have special rules for your own nationals?
Your Excellency, we submit that this would still fall afoul of the discriminatory obligation because Article 12.4, although we recognize, does state that no one shall be arbitrarily deprived of the right to enter his own country under the ICCPR, we submit that run-of-style must first show that it was necessary or reasonable to even make the differentiation to begin with, before it can claim that it does not fall afoul of the discriminatory obligation.
Regardless of human rights obligations, doesn't every state have an obligation owed to other states to admit its own nationals?
Your Excellency, we submit that the obligation that a state owes to its own nationals in this regard does in fact exist under Article 12.4 of the ICCPR. However, we submit that with regard to the question of discrimination, there must be a reasonable and objective criteria for differentiation. And Your Excellencies, this was stated at paragraph 13 of the Human Rights General Comment number 18 regarding the prohibition of discrimination. And here we submit that there was no such reasonable and objective criteria, given that it was not necessary to even make this differentiation to begin with. Because on the evidence, Your Excellencies, we note from paragraph 3 of the facts that run-of-style is a wealthy nation with a GDP of 1 trillion and therefore could have allowed persons to enter as long as they were quarantined in run-of-style's facilities. For these reasons, we submit that there was a breach of Article 43.1 of the IHR, and accordingly, run-of-style is obligated to compensate Aprilia for the resulting economic losses, because this follows from the general principle of international law to make full reparation for an internationally wrongful act. And this was articulated by the predecessor of this court in the 1928 Causal Factory case. With that, Your Excellencies, I now turn to the second submission, that run-of-style violated the customary duty of non-intervention in persisting to harbor Ms. Formund within its consulate when she was charged with 3 domestic crimes. And run-of-style's refusal to surrender this prosecuted individual, in the words of this court in its 1950 asylum decision, withdraws the offender from the jurisdiction of the territorial state, in this case Aprilia, and constitutes an intervention in matters which are exclusively within the competence of that state. Now, against this, we note that the respondent had contended at pages. Yes, Your Excellency.
Hasn't this court set a very high standard for intervention? If you consider, for example, the merits decision in the Nicaragua case, I think that it's a very high standard in terms of coercion, essentially. How does that standard, how is that standard met here?
Your Excellency, we do recognize that paragraph 205 of this court's 1986 Nicaragua decision, the standard for intervention was said to be that of coercion, indeed, as Your Excellency put it. And according to Oppenheim's international law, the definition of coercion means that the interference must be forcible or dictatorial, in effect depriving the state intervened against control over the matter in question. And here we submit that that standard of coercion was met because Aperplia was deprived of control over its domestic criminal justice system, given that Rano Stallo's harboring of Ms. Formund took place in an inviolable consulate, therefore withdrawing Ms. Formund from the reach of Aperplia's domestic criminal justice system. This, we submit, meets the standard of coercion, and therefore intervention is made out. And Your Excellencies, we note that the respondent contended at pages 10 and 12 of its memorial that asylum can be granted if an individual's liberty would be arbitrarily deprived. However, Your Excellencies, that is misconceived because the respondent is unable to show widespread and uniform state practice in this regard. In fact, state practice shows otherwise. First, concerning Ecuador's granting of diplomatic asylum to Assange in 2012. States such as Sweden and the UK have viewed this asylum as unlawful. And if I may quote the words of Foreign Secretary of the UK, the UK does not accept the principle of diplomatic asylum. It is far from a universally accepted concept. And again, last year, not yes, Mr. President.
Explain, are there any circumstances in which it would be proper to give sanctuary, if only briefly, to somebody in your embassy or consulate?
Your Excellency,
Any circumstances at all?
it is our primary submission that there are no conditions which would allow the grant of temporary sanctuary, as illustrated by the practice of states in refusing persons from entering their consulate for the purpose of seeking sanctuary. However,
Even if somebody's life is being threatened by a mob, for example?
Your Excellency, we do note that there is state practice in this regard, in which there is some states that argued that allowing persons to enter the consulate for sanctuary was possible if the person's life or liberty would be arbitrarily deprived. But to that, Your Excellency, our alternative submission is that even on the facts of our present dispute, there was no such risk of an arbitrary deprivation of liberty. Your Excellency?
Yeah, the agent, would you like to elaborate a little on the statement that I believe was made by your state on what was going to be the repercussions of the detention in this situation? It seems that there's at least an argument that there is some arbitrariness and some foregone conclusion as to what might happen to the individual who I think it's clear was in a whistleblowing situation, and I believe that one could point to some jurisprudence that argues whistleblowers are entitled to a heightened degree of protection, especially if they're public servants.
Your Excellency, we do note from the clarifications that Aperplia stated that as a result of Ms. Formund's actions, she would be, the prosecution would charge her for 20 years imprisonment. However, Your Excellency, while this was the prosecution's decision, we do submit that this was not a foregone conclusion before the Aperplian courts, which might very well have disagreed with the prosecution's position. With regard to the question on whistleblowing, Your Excellency, we do acknowledge that under Article 19 of the ICCPR, persons are protected with regard to the freedom of speech. However, Your Excellencies, in the context of diplomatic asylum, we submit that the current state practice as it is shows that states are not willing to accept this as a reason for granting diplomatic asylum because, yes, Your Excellency.
Agent, what about complementary protection and non-refoulement obligation linked to human rights? I mean, the Inter-American Court of Human Rights has distinguished diplomatic asylum from non-refoulement obligations in respect of human rights obligations, and doesn't a state at least have to consider, if it does essentially allow someone to remain in a consulate, they have to then consider whether or not returning them might breach their human rights obligations, having allowed them to stay in the consulate, and assume some degree of control over them.
Your Excellency, indeed, we do acknowledge that there are human rights treaties that both Run of Style and Apropria are party to, which contain this non-refoulement obligation. However, our primary submission is that these human rights treaties do not contemplate the particular situation of diplomatic asylum and an individual being subject to the territorial sovereignty of the receiving state. But that said, Your Excellencies, even if we take the respondent's case at their highest, that there is some right on Run of Style's part to consider her claim for diplomatic asylum, we submit that the 15 days that Run of Style took were 15 days too long, Your Excellencies, because state practice shows that states decide within a matter of hours whether to grant an individual asylum. In the case of Venezuelan opposition leader Freddy Guevara, the Chilean embassy decided within 24 hours of his arrival to grant him asylum. In the case of former Chinese civil rights activist Chen Guangcheng, the American consulate decided within 24 hours to grant him asylum. And therefore, it is our submission, Your Excellencies, that it cannot be the case that Run of Style can persist in harboring Ms. Formund for an indefinite period on the pretext of considering her asylum claim, completely disregarding Apropria's territorial sovereignty. And therefore, Your Excellencies, we would urge this court to find that Run of Style violated the customary duty of non-intervention in refusing to surrender Ms. Formund upon request, because even taking the respondent's case at their highest, there was no risk of an arbitrary deprivation of liberty. Unless Your Excellencies have further questions, may it please the court.
Thank you very much, Agent. And I now call upon the second agent of the applicant to address the court.
Mr. President, Your Excellencies, good day, and may it please the court. My name is Rebecca Liu, and I will be making 2 submissions today. My first submission concerns whether this court has jurisdiction over the counterclaim. My second submission concerns the merits regarding the lawfulness of Apropria's shooting down of the Montian aircraft. As these submissions are in the alternative, should Your Excellencies agree with our first argument on jurisdiction, then this disposes of the counterclaim in its entirety, and there is therefore no need to hear our second submission on the merits. Turning to our first submission, we say that this court has no jurisdiction over the counterclaim because it is excluded by Apropria's reservations. At paragraph 48 of the facts, you will see that Apropria has consented to the court's jurisdiction by way of making a declaration under Article 36(2) of the ICJ statute. However, if we look further down below, at paragraph 49, we will see that this consent is qualified by 2 reservations. 1, Aproprian military activities. 2, matters essentially within Apropria's domestic jurisdiction. In our submission, the last sentence, which reads, as determined by the government of the United Republic of Apropria, only attaches to the reservation on domestic jurisdiction. Now, turning then to apply the reservation on domestic jurisdiction, we note that the respondent in the memorial seeks to invalidate our reservation.
You say, counsel, that it only applies to the second reservation, but grammatically, looking where the commas are, that doesn't seem necessarily correct. How do you justify your view? Please, thank you.
Your Excellency, beyond looking at the commas, we refer to the interpretive principle of this court in interpreting declarations, and indeed as held by this court in its 1998 fisheries jurisdiction case at paragraph 49 and 69, declarations must be read in a natural and reasonable way and in light of international law and practice. Now, to the extent that states have only ever used the subjective qualifier to attach to reservations on domestic jurisdiction, we submit that a natural and reasonable reading.
Agent, would an alternative, if you look at the United States reservation in the 1940s, they had separate subparagraphs. So the Connolly Clause and the Vandenberg Reservation were separated by separate paragraphs. And I believe the United Kingdom had a subjective reservation in 1957, which actually attached to security-related matters. So it wasn't domestic jurisdiction clause, it was related to military activities and security-related matters. So don't both of those factors point against your reading of the particular provision?
Not necessarily, Your Excellency, and this is because it is a state's sovereign right to structure their reservation in any way they so please. And it is our submission that Appropria's structure and intention was to only attach the qualifier to a limb on domestic jurisdiction.
Well,
and perhaps,
Counsel, of course, you're entitled to draft it entirely how you like and put commas wherever you want to put them. But it would have been much clearer if you hadn't put the second comma, is all I can say. But perhaps it doesn't really matter, this question.
yes, perhaps, Your Excellency, and this is because we do note that in any case, the question before this court is actually whether this subjective reservation is indeed valid as a matter of international law. And against this, we do note that the respondent seeks to invalidate our reservation for contravening the competence principle embodied in Article 36(6) of this court statute. But we say this is misconceived. Indeed, as noted by Judge James Crawford in his 1980 article on the legal effects of automatic reservations, Article 36(6) merely allows the court to factually determine the existence of its jurisdiction, and our reservation does not deprive this court of its adjudicatory function, since it is still the final arbiter as to whether Appropria has validly invoked this reservation as a matter of fact. And we have, Your Excellency, having considered the matter to be purely domestic, even before the counterclaim was filed. This can be found at paragraph 45 of the facts, and therefore we request this court to find that it has no jurisdiction over the counterclaim. But in the alternative,
In fact,
Mr. President,
you're not relying upon the subjective nature of either of these reservations. Is that correct?
Your Excellency, for clarity, we are. In relation to our domestic jurisdiction reservation, we are submitting that the subjective nature is valid and that we have validly invoked the reservation in good faith. But in the alternative, we turn to our objective reservation concerning military activities. And here, the court can objectively determine whether the factual circumstances show that it was an Appropriate military activity. Now, on its plain meaning, a military activity involves the use of military instruments for purposes like protecting a state's territorial integrity. And we get this definition from Judge Jesus's separate opinion in the 2019 International Law of the Sea Tribunal decision between Ukraine and Russia at paragraph 15.
Agent,
Yeah. Yes, Mr.
that decision related to Article 298 of the Law of the Sea Convention. Is it appropriate to have regard to jurisprudence in respect of a particular Law of the Sea Convention in interpreting a optional clause declaration in these circumstances? I mean, can we have regard to that jurisprudence?
Indeed, Your Excellency, it can have regard to such jurisprudence pursuant to Article 38(1)(d) of this court statute. Now, we recognize that that particular provision was dealing with Article 2981(b) of UNCLOS in relation to the definition of military activities. But we also do note that this court, in its 1998 fisheries jurisdiction case, in paragraph 71, did hold that in absence of a definition in respect of the state's reservation, states are intended to have adopted the meaning that is generally accepted at international law. And here we would submit that given that there are over 190 state parties to UNCLOS, this would be a relevant definition at international law.
In any
No.
event, you're relying upon a separate opinion of Judge Jesus of the Law of the Sea Tribunal. Is that your strongest argument?
Your Excellency, not necessarily. That is one of our arguments, but we also do refer to the main order at paragraph 66, which defined a military activity as an activity that must have regard to the circumstances, the objective facts contained therein. And here we submit that it was a military activity, not just because we employed military instruments, but the instruments, Your Excellency, were employed for a purpose of protecting our state's territorial integrity against an imminent terror attack. Yes, Your Excellency.
Agent, I mean, there's uncertainty, or there was uncertainty, wasn't there? I mean, the aircraft was not fired upon to destroy it. It was fired upon to force it to land, which to me suggests that those firing upon it were uncertain about his exact intentions, and it was more of a law enforcement activity. If it had been fired upon in order to destroy it, then I would concede that that would have been a more straightforward set of circumstances. What do you say to that?
Well, Your Excellency, in our submission, the lack of a destructive intent is at best equivocal. And this is because we do know that the military, especially in times of war, do force enemy combatant planes to land and subsequently detain them. But if we look at paragraph 42 of the facts, the intention at the point of firing was because there was a fear that this was the imminent terror threat we were forewarned about. And it is this use of force that is Rana Styles' subject of its counterclaim, and therefore we submit that this particular use of force was a military activity, and therefore this court has no jurisdiction over the counterclaim. However, even if it did, we are happy to turn to the merits of the case. And here we submit that Aprapulia did not violate international law by shooting down Montian aircraft.
I'm very happy to hear about the merits, but you're not going to say much about domestic jurisdiction other than relying on the fact that it means whatever you say it means, because it's subjective. Is that right?
No, Mr. President, and perhaps turning back to canvass the domestic jurisdiction reservation. Now we submit not only that it is valid in law, but that we have validly invoked it because the circumstances show that the matter transpired in Aprapulian territory and exclusively concerned Aprapulian instruments and personnel. And to that extent, it can be considered an essentially domestic affair.
Even though there were human rights implications, perhaps?
Your Excellency, now we do acknowledge that whether there are human rights instruments engaged is relevant at the merit stage once this court has determined jurisdiction. But this court has also held in its 1998 fisheries jurisdiction case at paragraph 55 that the question on merits is a distinct process from the question on jurisdiction, and therefore inquiries as to the latter stage cannot inform the former question on whether there is consent to the court's jurisdiction. But even if this court finds jurisdiction, we submit that there was no violation of international law when we shot down the Montian aircraft. Now, we do note that the respondent's principal contention is that we breached Article 3 Bis A of the 1944 International Convention on Civil Aviation. This obligation requires states to refrain from using weapons against civil aircraft in flight. Your Excellencies, there are two reasons why we did not breach this provision.
Can I interrupt for a moment? Are you assuming that the Chicago Convention is applicable here in the first instance?
Your Excellency, our first argument is that the Chicago Convention does not apply. And our second alternative argument is that Aprapulia was lawfully acting in self-defense. And the first point to be made here is that the Chicago Convention only governs international civil aviation. And this is made quite clear in the very title of the convention. Now, even Article 96B of the Chicago Convention defines international air service as air service which traverses through the territory of other states. So to the extent that this was an Aprapulian registered plane that remained in Aprapulian territory at all material times, we submit that the unilateral intention on part of the pilot of the plane cannot make a flight international. Yes, Your Excellency.
No, you've
Certainly. And to that extent, Your Excellencies, we submit that the Chicago Convention in Article 3 bis does not apply. However, even if we were to take the respondent's case at its highest and accept that
Sorry,
Article...
before you leave your first point on this,
Yes, Mr. President.
what do you make of the fact that there was a proposal during the negotiation of 3 bis to limit it expressly to foreign aircraft, and that wasn't included?
Your Excellency, are you referring to the proposal by the Austrian-French proposal of 1983, specifically on the 23rd of November?
I believe I am, yes. Thank you.
Well, Your Excellency, for clarity, that proposal initially recommended the protection of civil aircraft of all contracting states. But that proposal was eventually rejected because states wanted to ensure protection of all foreign aircraft and not only foreign aircraft of contracting states of ICAO. And to that extent, it does not change our submission in any way because the intention was only ever to protect foreign civil aircraft. And this is consistent with the purpose in which Article 3 bis was employed, Your Excellency. The reason for its introduction was following the events of the downing of KEL Flight 007, when it unfortunately trespassed Russian airspace. And therefore, while states wanted to protect their own aircraft traversing through foreign airspace, the intention was never to undermine the state's own sovereignty to regulate purely domestic aircraft. Therefore, we submit that 3 bis does not apply. However, even if it did apply, we accept and submit that Abraplue was lawfully acting in self-defense pursuant to Article 51 of the United Nations Charter. Here, following 9/11, state practice events that Article 51 could apply, first, against non-state actors. This was evinced in Security Council Resolutions 1368 and 1373. Now, second, state practice also evinced that it could apply in anticipation of imminent armed attacks.
But Agent, don't you have the fundamental problem that there was no imminent armed attack? It was essentially mistaken anticipatory self-defense. I appreciate there's a degree of uncertainty in every case of anticipatory self-defense, but this is a mistake situation. There was no imminent attack. How do you overcome that?
Your Excellency, we would respectfully disagree, and we would submit that there was an imminent armed attack. And we pause at this junction to note that the concept of imminence goes beyond temporal terms, but looks to the gravity of the attack and the capability of the attacker. And this was noted by the 2005 Chatham House Principles, Your Excellency. And here we submit that the context of the 26th of June must be borne in mind. Now, a week earlier, we had received an Interpol report detailing that the FOJ, a transnational terror group, was planning an attack specifically on a capital in the region and using a bomb-laden civilian airplane. Now, this could have meant one of two things.
Counsel,
Yes, Mr. President.
there are a number of questions raised by your argument, including whether an armed attack by a non-state actor can count in light of our previous pronouncements in the cases you're familiar with, and the whole question of anticipatory self-defense still being very controversial given the terms of Article 51 of the Charter, the express terms. What do you have to say about our previous pronouncements? Yes, please.
Your Excellency, well, first, in relation to non-state actors, this court never actually had occasion to rule on whether the armed attack required state attribution, even though we do note that this court, in its 2004 Wall Advisory Opinion, at paragraph 139, did state that Israel could not rely on the UN Security Council Resolutions 1368 and 1373 to invoke Article 51. But, Your Excellencies, this pronouncement was made because Israel was dealing with a situation of domestic terrorism which naturally did not engage threats to international peace and security, and therefore Israel could not rely on Article 51. And this,
That was, Council, that was terrorism coming from occupied territory, arguably. What you have here is terrorism, if you want to call it terrorism, coming from your own territory.
Your Excellency, not quite, even though we do acknowledge that this was perhaps an attack that emanated from our own territory. At all material times, as a matter of objective fact, this was a transnational terrorist group that had not only been blamed for several capital bombings over the past 3 years in Ottawa, London, and Abuja, but also even been listed on the UN Security Council's consolidated list as an official terrorist organization. So those facts are distinguishable from our present. Your Excellency?
Agent, you mentioned the importance of the context, and I appreciate that it is extremely important, but the context also includes the fact that airport security in Apaplia appears to have been extraordinarily lax. An aircraft was left unattended on the tarmac for a month. And I'm worried about the policy implications of a relatively lax approach to self-defense and state relying on mistaken self-defense when, in fact, it really ought to assume the risk of getting it wrong when it has not taken everything it could, all the measures it could have taken to avoid the risk.
Now, Your Excellency, in our submission, the events of the 26th of June would still have likely materialized even if Apaplia had taken additional precautionary measures or had attended to that plane on the tarmac. And this is because we know that Ms. Gorhai had covertly arranged for a plane to be made available, and indeed her presence at the security would not have in itself raised suspicions given that she was a Montian aircraft pilot. But beyond that, whether we contributed to this situation, so as to speak, is only relevant if we were invoking the customary right of necessity as enshrined in Article 25 of the ASR. But we are invoking a separate defense of self-defense, which is agnostic to the inquiry. Yes, Your Excellency?
I'm somewhat intrigued by the characterization of the pilot. In terms of the facts, do you think it's relevant that the pilot was not able to respond to you when you tried to make contact? Do you think it's relevant that the plane was flying in the early hours of the morning, at which time one would imagine that there were not too many people in any offices that you feared might have been attacked? In these circumstances, how do you argue that self-defense was clearly justified?
Now, Your Excellency, perhaps the fact that this plane took off in the dead of the night would even seem to confirm our suspicions that this was the threat that we forewarned about. But beyond that, Your Excellency, we would say that any dropping of bombs on our capital, notwithstanding the time of the day, would have caused catastrophic effects. Now, Bhutan houses Apaplia's banking and financial sector, which is the key contributor to our GDP. So any attack on our capital would have been catastrophic, therefore amounting to an imminent armed attack. And given that we only used force at the very last 3 minutes when this plane was 3 minutes away from our capital, we say that this use of force was necessary. Your Excellency, I do note my time has elapsed, unless I may be of any further assistance. Thank you.
Thank you very much, Counsel. I now invite the first agent for the respondent to address the court.
Mr. President, Your Excellencies, good evening and may it please the court. My name is Krisha Romano Weigel and I appear for the respondent, the Democratic State of Ranovs Tayo. I am joined today by my co-agent, Mr. Romel Justin Redoble, and our off-counsel, Mr. Edward Dominic Emilio. For 22 minutes, I shall address the respondent's first and second submissions, pertaining first to its entry regulation, and second, to its refusal to surrender Ms. Keinblatt Vormund. And if Your Excellencies have no preliminary inquiries, may I proceed?
Please do.
Your Excellencies, in the Risk Assessment Manual issued by the World Health Organization in year 2012, it was provided that for the suppression of communicable diseases, travel restrictions may be appropriate. And this is in acknowledgement of the fact that the 2002 SARS, the 2009 AH1N1, and the 2012 MERS all became global threats by spreading along air travel routes. Considering this, respondent comes before the Honorable Court today, pleading that it adjudge and declare that respondent's entry regulation is consistent with international law. The applicant, however, claims otherwise on three primary grounds. First, Your Excellencies, they allege that there is a violation of Article 43.1 of the 2005 International Health Regulations, or the IHR. Second, they allege as well a violation of Article 42 of the IHR, taken together with Article 12, Paragraph 4 of the ICCPR. And finally, that by reason of these alleged violations, respondent must now compensate the applicant for its claimed economic losses. Your Excellencies, in order to help facilitate the present proceedings, respondent shall refute these allegations in the same order as the applicant has presented them, as far as practicable. And we turn first to Article 43.1 of the IHR. The respondent notes the allegation of the applicant that it was more restrictive to trade to impose a statewide prohibition against Aprapluia because it had only 9 confirmed cases at that time and because the Segura province was already locked down. Respondent, however, submits that their reliance on these facts are misplaced, Your Excellencies. And this is because, according to the Risk Assessment Manual, the number of confirmed cases is but one of the many factors that must be considered in providing for an additional health measure. Another factor to be considered, Your Excellencies, is the travel volume between the destination state and the applicant or the departure state. In this case, it is noted in paragraph 3 of the agreed facts that 25% of the foreigners in Aprapluia are residents or citizens of Ranovs Tayo. And moreover, 40% in fact transit to and from Aprapluia through the Bogpadayo Airport. This would mean, Your Excellencies, that there is indeed a high travel volume and therefore a higher degree of exposure, which means ultimately a higher risk of disease transmission. With regard to the allegation that the Segura province has already been quarantined, respondent notes that the quarantine in paragraph 27 of the agreed facts was imposed only on June 5 in the morning. This was 10 days from the detection of the first 2 cases in May 25. And because the JVID-18 is capable of asymptomatic transmission, it is quite possible, Your Excellencies, that an asymptomatic individual would have left the Segura province before the imposition of the quarantine or the lockdown, and this would have led to the infection of other individuals outside, as is confirmed by clarification paragraph number 7, which provides that by November 20, applicant would have 450 confirmed cases outside of Segura, in addition to the 1,995 cases in Segura province. Now, as a matter of law, Your Excellencies, respondent submits a threshold, and this is provided for in footnote 3 to Article 5.6 of the SPS agreement, which provides that a measure is more restrictive if there is a...
Agent, can I ask, how is it that this court can have regard to the agreement on sanitary and phytosanitary measures in respect of the obligations of the state under the international health regulations?
Of course, Your Excellency, respondent submits that the SPS agreement, as well as the cases of WTO interpreting said agreement, are of particular relevance in this case for 2 reasons. First, because it is noted that pursuant to Working Paper 118 of the WHO, it is submitted that the 2005 amendment to the IHR was born out of a joint panel between the WHO and the WTO SPS committee. Therefore, the SPS agreement is context within the meaning of Article 31, Paragraph 1 of the VCLT. And second, Your Excellencies, we may also apply Article 31, Paragraph 3C of the VCLT pertaining to the principle of systemic integration. With that, Your Excellencies, we move back to our argument, and respondent submits. Yes, Your Excellency. Your Excellency, I do apologize. I unfortunately cannot hear you.
Apologies. I would like you to address the point, please. The justification of your taking measures directly in the face of a recommendation from the WHO. If we go back to first principles in this matter, what you did was absolutely contrary to the WHO recommendation and request. And how do you justify the measures that you took simply from that perspective?
Your Excellency, in that regard, respondent acknowledges that there is a duty under Article 43.2 to base the measure on WHO advice. However, pursuant to paragraph 189 of the appellate body report on the EC hormones case, the word to base on means to take into account or to take into consideration the piece of evidence, in this case, the WHO advice. In paragraph 12 of the agreed facts, it is clear that respondent has done so because Health Minister Adasap Adapi of Ranavstayo did declare that Ranavstayo was aware of what the WHO has and has not recommended, but because of scientific evidence, it was still necessary to provide for travel restrictions. And respondent submits
You
here.
also, counsel, argue that there was no specific guidance or advice from WHO. I think the word specific could be important in Article 43.
Indeed, Mr. President, there is a specific WHO recommendation issued on April 20 of 2018, as can be gleaned in paragraph 8 of the agreed facts. However, respondent submits that nonetheless, there is still no violation, even if respondent was asked to reconsider its application, because it had taken into consideration scientific evidence as basis for its travel restriction.
Can you elaborate a little on the scientific evidence point that you're making? If we do accept that you are entitled to rely on WTO jurisprudence, to what extent are we as a court required to look into the detailed scientific evidence that you have relied upon?
Your Excellency, in the EC hormones case, as well as the Japan agricultural products case, it is provided that there is a requirement that the scientific evidence be sufficient. Respondent submits to that regard that the evidence that respondent is submitting before the Honorable Court is sufficient. It is noted, Your Excellencies, that in paragraph 7 of the agreed facts, as early as April 15, 2018, scientists have already determined the incubation period, the reproduction rate, and as well the mode of transmission of the disease. And since these have been accepted...
Agent, can I interrupt there? I mean, paragraph 7 relates generally to the particular disease, but don't we need to see the science or assess the science in support of the measure rather than the science in relation to the disease, if that distinction makes sense?
Indeed, Your Excellency. In fact, in paragraph 193 of the EC hormones case, it is required that for there to be a rational relationship between a scientific evidence and a measure, there must be a risk assessment. And in this case, in paragraph 10 and 51 of the agreed facts, respondent has conducted 2 intensive risk assessments, the very conduct of which...
Agent, this is exactly my problem. We have in paragraph 10 a reference to what Ranavstayo called the best scientific evidence. And in paragraph 51, we have reference to what it asserted to be the best scientific evidence. So it seems that all we have is the respondent's assertions in that respect. And I'm worried about the position of the court in those circumstances.
Your Excellencies, perhaps this would go into the question of whether the scientific evidence submitted by the respondent is self-serving. In this regard, however, respondent submits that it is not, primarily because it is the IHR itself which provides every state with the competence to determine its own scientific evidence. And in any case, the Central Biodefense Institute of respondent was in direct coordination with the WHO in the study of the virus. Therefore, Your Excellencies, this would certainly support the notion that respondent was in possession of qualified scientific information. In that regard, respondent submits that there is compliance with Article 43.2 and 43.1 of the IHR. We turn now, Your Excellencies, to the allegation with regard to discrimination under Article 42 of the IHR in relation to Article 12.4 of the ICCPR. Now, respondent is prepared to concede, Your Excellencies, that Article 12.4 on the right to return to one's own country does cover permanent residents as well, which are prohibited from entering Ranav's Tayo. And this is pursuant to paragraph 20 of General Comment number 27. But in any case, from the very text of Article 12, paragraph 4, and in paragraph 21 of General Comment 27, the limitation to the right to return to one's own country may be allowed, provided it is not arbitrary. And in this case, respondent submits it is not arbitrary because there is a public health rationale which supported the prohibition. And this rationale, or good reason, Your Excellencies, is because if we allow these non-Ranavstaya nationals to enter, in addition to the Ranavstaya nationals, this would lead to an undue burden upon the state, which would very well saturate or overwhelm the health facilities of respondent, and this would be detrimental to its response to the pandemic, which is novel, compounded with the uncertainty because it was at that time still at the beginning of the epidemic curve. Therefore, Your Excellencies, there is likewise no violation of Article 12.4. But if this Honorable Court finds that there is a violation, respondent submits that compensation is still not proper because of the absence of a direct causal link as required under Article 31 of the Draft Articles on State Responsibility, which provides that the obligation to make reparations arises when there is injury caused by an internationally wrongful act. And the direct causal link is absent in this case because the applicant itself had provided for a total lockdown of the Segura province, which would have affected its own tourism industry. Therefore, it is not entitled to compensation. And with that, Your Excellencies, we turn now to the second claim. Yes, Your Excellency? I apologize once again, Your Excellency.
Are there any public policy arguments against allowing compensation in a situation like this, in your view?
Yes, Your Excellency. Respondent submits that to allow compensation in this case, when there is difficulty in establishing a direct causal link, would be unjust. This is because it would be improper, Your Excellencies, to hold a state responsible for the highly attenuated economic ripple effects of a regulation of general application. With that, Your Excellencies, we turn now to the second claim. And under this claim, respondent submits that its refusal to surrender a whistleblower who, out of fear for her life or her freedom, sought protection from respondent's consulate in Segura is valid and consistent with international law.
Councillor, can I interrupt right at the start? This notion of whistleblower, it's a very pejorative term. Does it help your case to throw that around?
Indeed, Your Excellency, it would help the case of respondent, primarily because a whistleblower, as characterized by Special Rapporteur David Kay in page 25 of his 2015 report on the freedom of expression, is one who reasonably believes...
What value should we attach to somebody's report?
Your Excellency, the respondent submits that this report should be given persuasive value, pursuant to Article 38(1)(d) of this Honorable Court statute, as it is an issuance of a highly qualified publicist. And in that regard, respondent submits that because Ms. Kainblatt Vormund is a whistleblower, this would show that the disclosure of the information was pursuant to public interest, which would help the characterization of her crime to be political in character. But first, Your Excellencies, we turn to the legal basis of the refusal to surrender, as this is primarily impugned.
Are you saying, Councillor, that anybody who shouts about what the government is up to is entitled to special consideration?
No, Your Excellency. I mean, Mr. President, I do apologize. No, Mr. President, regard must always be had to the context of the case. In fact, in paragraph 28 of the UNHCR handbook, the political character of a crime must be determined on a case-by-case basis. However, respondent submits that in this context, the crimes against Ms. Vormund was politically motivated. This is because her disclosure was accorded with strong public interest and directly contravened with the confidentiality policy of the state. Therefore, while her crimes appear prima facie to be common in character, they are in fact and in reality.
That, there's a right to give asylum to anyone who is accused of what you call a political crime?
Mr. President, we must clarify that Ms. Kainblatt-Vormund has not been granted asylum. What is clear from paragraph 25 of the agreed facts is that she is merely an applicant for asylum, but this does not detract from the standing of the respondent that she is still entitled to protection pursuant to the principle of non-refoulement under customary law. And respondent, with regard to the second question of Mr. President, submits that Ms. Kainblatt-Vormund in this particular context would be entitled to complementary protection precisely because she had a well-founded fear of persecution. And please allow the agent to substantiate. Your Excellencies, we are aware.
Agent, I'm concerned relating back to the President's question about whistleblowers. I mean, if you look at paragraph 34, it looks as if the respondent is interested in the information provided by Ms. Vormund as being of great importance to us, in a sense, as a source of information, almost an intelligence role. That, to me, makes the whole non-refoulement argument much more complex, because it looks much more likely to be interfering in the state's internal affairs, to be using agents of the state to derive valuable information. It's not a straightforward protection situation anymore.
Your Excellency, we do concede that the refusal, or rather the removal of Ms. Kainblatt-Vormund from Apra-Pluian authorities would constitute an interference, and we are prepared to concede that in this case there may have been an interference in the sovereignty of the applicant. However, we submit that pursuant to the asylum judgment, that interference may still be recognized as valid, provided there is legal basis. And that legal basis...
Counsel, do you have any evidence at all that she is likely to not have a fair trial?
Yes, Mr. President. The respondent points to 3 facts in the agreed statement of facts that would substantiate the well-founded fear of persecution and the possibility of arbitrary incarceration. The first fact, Mr. President, Your Excellencies, would be in paragraph 21 of the agreed facts, which would show the subjective element of well-founded fear of persecution. And it is that after her conversation with the NBL director at the NBL, she believed and she had no doubt in her mind that she would be in deep trouble. Second, Your Excellencies, in paragraph 31 of the agreed facts, it is noted...
To go back to that one, in deep trouble because her employer said so, is that sufficient?
No, Your Excellency, because that would only pertain to the subjective element, but because she has been charged with 3 crimes, all sought to be imposed at their maximum periods by the prosecutorial arm of the government, then this would show the demonstration of her fear and of the threat of deep trouble against her. And in addition to this, respondent forwards as well paragraph 20 of the agreed facts, which shows that Apra-Pluian police officers arrived at her house in daylight, Your Excellencies, only hours from the time of the posting of the tweet sans a warrant, and the immediate chase that took place after for 19.
Doesn't that just show that they're rather efficient?
I apologize, Mr. President.
Doesn't their swift arrival just show that they're rather efficient?
Indeed, that may be the case. However, respondent submits that because of the totality of the circumstances, coupled as well together with the history of government retaliation against persons or whistleblowers like her, that this would still engender a well-founded fear of persecution on the part of Ms. Kainblatt-Vormund. And therefore, Your Excellencies.
Agent, could I just return to Mr. President's question, which is there any evidence that she would be likely not to have a fair trial? You've talked about the prosecution requesting the maximum service sentence, but do you have further evidence to found upon that there would be realistically a right of persecution, a fear of persecution?
Yes, Your Excellency, we may look into the disproportionate character of the penalty that would have been meted against her, and this disproportionate penalty.
How do you have any? Did you know what penalty would have been given to her?
The paragraph 31 of the agreed facts, as well as the clarifications, would show, Your Excellency, that there is a possibility that she would be imprisoned for 20 years for the non-disclosure agreement violation. Now, the respondent is aware, Your Excellencies, that this trial has not yet happened. It is quite possible that she would not have been imprisoned for said number of years. However,
if she fears her human rights will be trampled on, isn't that something she can raise at the trial?
Indeed, Your Excellency, that would be one thing that she can raise at the trial. However, respondent submits that because the perceived threat against her life was so immediate and severe that she could have run to the consulate of respondent, then respondent's human rights obligations, being that she was then in the jurisdiction of the respondent, has been triggered, and there was now an obligation to ensure that her life and her freedom was protected pursuant to the principle of non-refoulement, which gives rise to complementary protection under international human rights law. With that, Your Excellencies, if I may no longer be of assistance to the Honorable Court, then respondent ends our submissions. We thank the court for its time and indulgence. May it please the court.
I thank counsel for the respondent. I now invite the applicant to speak in rebuttal. Sorry, I'm getting confused. I invite the second counsel for the respondent to address us. Thank you. Please, you have the floor.
Mr. President, Your Excellencies, good day and may it please the court. My name is Ramel Justin Rebuttal, and it is an honor for me to appear before the International Court of Justice, pleading in behalf of the respondent, the democratic state of Rwanda style. For the next 21 minutes, I shall be discussing the respondent's third and fourth claims. Third, with regard to this court's jurisdiction over the Ranamstayan counterclaim, and fourth, concerning the shootdown of the Mclennan Airways aircraft. I apologize, Your Excellencies. Your Excellencies, during the height of the pandemic in 2018, Ms. Kaimblot Vormund, whose life was at risk due to the disclosure she's made, fled with Ms. Goye towards her capital to seek favorable refuge. However, at least 2 hours before the sunrise of the 26th of June of 2018, both their bodies were found in the wreckage of an eviscerated plane crashed in the Abercrombie forest. Your Excellencies, the case before the court today is one regarding a state investing upon itself the power to escape this court's jurisdiction on a matter of convenience. Thus, we plead the court that it should rule on the matters concerning the shootdown of the Mclennan Airways aircraft. We turn first to the third claim with regard to this court's jurisdiction over the Ranamstayan counterclaim. Mr. President, Your Excellencies, we note a concession made by the applicant that this court may in fact interpret the reservations in good faith. Thus, Your Excellencies, we will no longer argue on the invalidity of the reservation. We will proceed, Your Excellencies, as to whether the dispute in this case falls within the scope of the reservations made by the applicant. Turning first to the issue of military activities. Your Excellencies, the applicant earlier argued, yes, Your Excellencies.
Can I ask, in relation to the good faith obligation, does that mean that provided the applicant makes its determination to invoke the condition in the reservation in good faith, then that is, are you considering that would be their entitlement then to rely on the reservation?
We concede, Your Excellencies, that this would be the matter, as it was recognized, in fact, by this court in the 1998 Fisheries Jurisdictions case, that an interpretation of the self-judging character of a reservation should be made in the natural and reasonable way, having regard to the intent made by the person, or the state rather, making that declaration. And in this case, Your Excellencies, the court still has the competence to make a provisional determination as to whether the invocation of that reservation was in fact made in good faith. Thus, an examination as to whether the disputes do fall within the scope of these reservations is needed.
Sorry to labor on that. Does that mean that you have to show that that an attempt to rely on the reservation by the applicant is in bad faith in order for them to you to succeed?
No, Your Excellencies, not necessarily. What we submit, Your Excellencies, is that if the matters do not fall within the scope of the reservation, then that invocation would then tend to justify the unlawful conduct made by that state. And so, Your Excellency, when the matters do not fall within that scope, this court should still exercise its jurisdiction. Now, we proceed, Your Excellencies, to the matter on military activities. The applicant earlier argued that there is, in fact, a threshold placed in the separate opinion of Judge Jesus as to what matters are concerning military activities. However, Your Excellencies, we proceed to the dichotomy in the presentation of the PCA in the South China Sea case as to what matters are actually quintessentially military. The threshold, Your Excellencies, presented by the PCA is that it is military when there is military force on one hand and military force on the other arrayed in opposition against each other. Thus, there should be no hierarchical difference into the forces involved in order for it to fall as a military operation. However, Your Excellencies, as can be gleaned in paragraphs 43 and 45 of the agreed statement of facts, it is clear in this case that what was involved was a gargantuan military fighter jet against a 12-seater propeller-powered plane. The difference in the hierarchy of these forces would then regard this situation as not a military activity. Now, we do also note, Your Excellencies, the presentation of the applicant as regards to paragraph 66 of the Ukraine.
Counsel, that argument about the disparity in the size of the airplanes, slightly strange. Are you suggesting that if 100 policemen go to arrest one person, then it's a military activity?
To clarify, Your Excellencies, this is only one factor in the determination as to what matters, as to what involves a military activity. We proceed, Your Excellencies, to paragraph 66 of the 3 Ukrainian vessels case as presented by the applicant, that there should be an analysis of the totality of the circumstances involving the purpose of the activity made by the applicant. Now, if we glean over paragraph 43 of the agreed statement of facts, it is clear that at the shootdown of the Mclennan Airways aircraft, the applicant state through Lieutenant Amalor Defesa used warning shots before it compelled the plane to land by shooting it at its wing route. This, Your Excellencies, manifests graduated use of force, which is in relation to law enforcement operations. We can also reasonably infer, Your Excellencies, that the policy of the applicant state is not actually to eliminate terrorist threat, but actually to arrest and prosecute to the fullest extent of the law. Terrorists, yes, Your Excellency.
Agent, I'm finding your argument a little difficult to understand. Are you suggesting that if there's a graduated use of force, then by definition there cannot be a military activity? That seems a little far-fetched to me.
To clarify, Your Excellencies, we are not submitting that the graduated use of force by a military vessel would indeed result to a law enforcement operation. What we are saying is that this court cannot rely on the characterization or the kinds of vessels involved, because as recognized in the 3 Ukrainian vessels case, in modern times, both the police and the military will be used in several measures such as counterterrorism. Thus, Your Excellencies, what should be the determining factor is the purpose of the activity sought. And it is clear in the facts that the purpose in this case is to arrest and prosecute to the fullest extent of the law these suspected terrorist agents. Thus, Your Excellencies, the applicant cannot rely on its military reservations exceptions made in its reservation. Now we proceed to the matter on domestic jurisdiction. We do note, Your Excellencies, that the applicant did not provide a threshold as to what matters are essentially within the domestic jurisdiction of the state. We present before the court the standard in Tunis and Morocco. In this case, Your Excellencies, the PCIJ rather, ruled that when a matter is governed by international law, such as that the question involves an inquiry into violations of international obligations, this would remove the matter outside the domestic jurisdiction of that state.
Agent,
Yes,
I'm a bit concerned about the permanent court's judgment, given that it was applying the League of Nations Covenant. And I think the language of the relevant provision was a matter solely within the domestic jurisdiction of the state, and the Charter has different language. What weight should we place on the different words that we use in the 2 instruments?
We do concede, Your Excellencies, that there is a semantical difference between the Tunis and Morocco case and in this case, because the language of the reservation made by the applicant is essentially, while Tunis and Morocco is solely. We submit, however, Your Excellencies, that following the interpretation made by this court in fisheries jurisdiction, that it should be interpreted in a natural and reasonable way. We submit that if there are, in fact, basis as to unlawful conduct of the state, such as violations of human rights, specifically Article 6, Paragraph 1 of the ICCPR, and Article 3 bis A of the Chicago Convention, following an interpretation in good faith, this court, Your Excellency, should then rule that this matter is not essentially within the domestic jurisdiction of Apertuya. Your Excellencies, this turns now the respondent to discuss the matters under the fourth claim. Your Excellencies, primarily, there was a question before the court today as to whether Article 3 bis A of the Chicago Convention applies. We wish to clarify, Your Excellencies, that the language used in terms of the international flights was only found in the Chicago Convention. We clarify that during the travaux préparatoires, as well as the preamble of the 1984 protocol to the Chicago Convention, which espouses Article 3 bis Paragraph A, the words domestic, foreign, and international was not included in the final text of the law. And following, Your Excellencies, the policy consideration that the text of the treaty must be interpreted in its ordinary meaning, there is no distinction then, Your Excellencies, as to what type of aircraft may be shot down and that would lead to the violation of Article 3 bis Paragraph A. Your Excellencies, we do also note that there was in fact a discussion with the President as to whether the Austrian reservation or objection to this characterization may be valid. We submit, Your Excellencies, the opinion of Professor Bin Cheng, who is also one of the drafters of the protocol to the Chicago Convention. He mentions, Your Excellencies, that in matters concerning the general safety of civil aviation and probable violations of human rights, the nationality of registration of a plane is an arbitrary matter which should not be used as an overriding consideration in matters concerning violations to Article 3 bis Paragraph A. Because, Your Excellency, states can change the nationality of a plane just to escape its obligations under the convention. Thus, we submit that Article 3 bis A of the Chicago Convention can be applied in this case. Proceeding now, Your Excellencies, to the violation of Article 3 bis Paragraph A. We note, Your Excellencies, that Article 3 bis Paragraph A prohibits the use of weapons against civilian aircrafts. And it is clear in this case, under paragraphs 42, 43, and 45 of the agreed statement of facts, there was a shoot down of a civilian aircraft stemming from the Segura Province Airport, whose flight was towards the Bogpadayo Airport in the respondent state's territory. Thus, there is already a prima facie violation of Article 3 bis Paragraph A. However, Your Excellencies, the applicant provided for legal justifications because they, in fact, said that there was an exercise of the inherent right of self-defense on the side of the applicant state. We prepare, Your Excellencies, two refutations in this matter. First, that a matter concerning the exercise of the right to self-defense under the United Nations Charter, particularly Article 51 thereof, does not allow the interpretation to non-state actors. Much less, Your Excellencies, it cannot rely on such provision because there is no actual armed attack, or at the very least, an imminent armed attack. Proceeding first to the question of non-state actors. Your Excellencies, we emphasize that although there was an existence of an alleged emerging custom in the United Nations Security Council resolutions in 2001, this court still in 2004 and in 2005, in its Wall Advisory Opinion and its decision on the armed activities in the territory of Congo, still stuck with the traditional interpretation that Article 51 should only apply to state-to-state activities, or at the very least, state to non-state actors whose actions are attributable to another state. Thus, Your Excellencies, because in this case, The suspected terrorist agents are non-state actors whose acts are not attributable to any titled state. Article 51 of the United Nations Charter cannot be triggered.
Agent, how do we deal with the historical practice in relation to self-defense? And I'm thinking in particular of the Caroline incident where you had non-state actors, their conduct was not attributable to any state, and the locus classicus for self-defense is derived from that particular instance. Is that just forgotten?
Certainly not, Your Excellency. And this discussion would lead then the respondent to the second submission, that there was in fact no imminent armed attack. We follow, Your Excellencies, the threshold in the Caroline case and the Webster's formulation that in order for an imminent armed attack to occur, there must.
Counsel, aren't you rather avoiding the question of my colleague, which is a separate question? Can you have self-defense at all against a non-state actor?
To clarify, Your Excellencies, we cannot aid this court with regard to that matter because the varying state practice currently with regard to non-state actors has not been considered to be part of customary or conventional law. We do stick with our submission, Your Excellency, however, that this court has never proclaimed that this armed attack should be done against a non-state actor. However, if this court, Your Excellencies, would allow interpretation of Article 51 of the United Nations Charter to include non-state actors, we go to our alternative submission that there was no imminent armed attack. Turning, Your Excellencies, to the Caroline threshold. The Caroline threshold requires that there must be an instant overwhelming, leaving no choice of means in no moment of deliberation in order for an armed attack to necessitate self-defense on another state. Here, Your Excellencies, it is clear that there was no overwhelming threat to deliver an armed attack against a 12-seater propeller-powered plane, based on three confounding factors. First, Your Excellencies, the flight was flying on a straight path heading to the heading to the Bogpadayo Airport of the Ranavstayan territory. Second, Your Excellencies, under paragraph 2 of the agreed statement of facts, it is clear that there was already considerable air traffic for at least 30 years between the applicant state and the Ranavstayan state. And this, Your Excellencies, would constitute normal behavior of planes flying from each other's territory. Furthermore, Your Excellencies, applicant state, although it employed a heightened alert based on its Interpol intelligence, did not make the airspace in its capital prohibited or in fact secured. Thus, Your Excellencies, these operational deficiencies on the side of the applicant would then mean that it was not necessary for it to attack the plane without any hostile or unfriendly behavior on its end. Your Excellencies, we do regard...
Counsel, it's not terribly convincing. How far away was this plane from the capital? And was it a normal route that was in regular use at this time to go from the province direct to the capital, or to your capital?
Your Excellencies, Mr. President, we do concede that the agreed statement of facts is not clear as to how far away the plane was. What is clear, Your Excellencies, is the plane crashed outside Buton, which is the city of Abercuya. Therefore, considering the distance from its capital city, the plane had not entered the airspace of its capital yet. And so the applicant shot down the plane even without any other evidence to do so. This, Your Excellencies, then would mean that in the course of the flight, there was still knowledge on the side of Lieutenant Ambler Defesa to note that it should not shoot down a plane without any other evidence, because this would be in violation of the objective test on the exercise of use of force.
What weight do you give to the failure of this plane to respond in any way? Is that normal for planes?
Your Excellencies, we do know that it would not be normal in ideal circumstances. But if we glean over the manual of the ICAO Council to the Interception of Civilian Aircraft, specifically Section 4 thereof, it is normal, Your Excellencies, for aircrafts not to respond to radio communications or visual signals, especially when there are in fact dysfunctions on the airplane's mechanism. We also note, Your Excellencies, that this plane was left in the tarmac of Siguro province for at least a month. Your Excellencies, during the shootdown as well, it happened in midnight or at the break of dawn. And the climate of the airspace as well as the weather during that time should be taken into consideration before shooting down an aircraft. Because, Your Excellencies, what is determinative?
All rather
Yes.
speculative. I mean, are you supposing that the pilot might have been asleep and that's why she didn't answer? Because it was early in the morning.
No, Mr. President, we wish to clarify that what we are stating in this case is that before a state can shoot down an aircraft, there should be evidence of hostile and unfriendly behavior. And for good reason, Your Excellencies, because Article 3 bis paragraph A constitutes violations to the obligation of states to protect life. And it's clear, Your Excellencies, that Lieutenant Amuler de Fesa saw two individuals riding the plane. And based on the knowledge of a lieutenant who is in fact a high-ranking official in the Air Force of Aperpuya, it was in his knowledge that a plane could not respond on the basis only of its dysfunction. Thus, it could have waited more before it shot down the plane. In practice, Your Excellencies, it could have waited for the plane first to make a dip or maneuver its path into diverging paths away from the capital, or increase its speed or accelerate towards the capital. And this would be unfriendly and hostile behavior.
Agent, do we know what altitude the aircraft was flying at?
No, Your Excellencies, but we can reasonably infer that it would be at least 3,000 miles above airspace because it is in fact a civilian aircraft, which is a 12-seater propeller-powered plane. And based on this altitude, Your Excellencies, it is clear that there was opportunity for a military fighter jet to see for the plane to land or make a dip before it could shut down, as this would result into the objective test of necessity and proportionality before a state could exercise its inherent right to self-defense. Necessity requires that there could be no other option. However, in this case, the applicant had multiple options before it could shoot down a civilian aircraft. Your Excellencies, this ends the submissions of the respondent with regard to the third and fourth claim. We thank this court for its time and indulgence. May it please the court.
I'm very grateful. Thank you to counsel for the respondent. And now I call upon the applicant to address the court in rebuttal. I think you have 3 minutes.
Mr. President, Your Excellencies, 2 points in rebuttal. First, regarding pleading 2, agent for the respondent argued that the harboring of Ms. Formund was justified because there was a well-founded fear of political persecution. However, Your Excellencies, in the latest edition of the UNHCR Handbook for Determining Refugee Status, which the respondent herself relied on, it was stated at paragraph 38 that there is an objective element, whether on the objective circumstances a person's life or freedom was threatened on account of their political opinion. An agent for the respondent was unable to show any evidence of such a threat, beyond referring to the prosecution's position and the police's rather expected reaction to a suspect fleeing her own residence. She was unable to adduce any evidence that the prosecution's position was a foregone conclusion before the Aperpuyan courts. There was no evidence that Ms. Formund would be subject to unfair trial. And therefore, Your Excellencies, we submit that in truth, there was no basis for harboring Ms. Formund within Rano Stayo's consulate, and we further submit that Rano Stayo's disrespect for the territorial sovereignty of Aperpuya must be condemned by international law. Second point of rebuttal, Your Excellencies, regarding the last pleading. Now, agent for the respondent asserted that the right of self-defense cannot be invoked against non-state actors. This is incorrect in law. My learned friend has omitted the wealth of state practice where Article 51 has been invoked against non-state actors, and particularly against terrorist groups. Following 9/11, 40 states expressly recognized US's right to self-defense against Al-Qaeda. Again, in 2006, when Israel invoked Article 51 against Hezbollah, and more recently in 2015, where states such as Norway, Turkey, Canada, France, and Denmark invoked Article 51 against ISIS. And recently, in the 2021 ARIA Formula meeting, states such as Australia, China, France, UK, and US recognized that Article 51 could be invoked against non-state actors. And ultimately, the respondents' position is untenable because threats to international peace and security emanate precisely from terrorist organizations that are non-state actors. And therefore, we submit that it would be impractical and unconscionable to tie the hands of the states in this regard, and this cannot be the state of international law. This concludes the applicant's submissions. May it please the court.
Thank you very much. I'd now invite the respondent to address us in rebuttal. You have the floor.
Mr. President, Your Excellencies, 2 points for rebuttal in order to directly respond to the rebuttal of the applicant. Turning first to the second pleading on the issue of the well-founded fear of persecution on the life of Ms. Kaimblat Formoon. We emphasize, Your Excellencies, that in the UNCHR comment, it is not a real harm that should be done, but only a foreseeable risk of harm or arbitrary deprivation of liberty, which is required in order to trigger complementary protection under the principle of non-refoulement in the 1951 Convention, as well as customary international law. The objective standard, Your Excellencies, is not just the probable prosecution of Ms. Kaimblat Formoon, but also the disproportionate application of the laws of appropriate state. As can be gleaned from paragraph 6 of the agreed statement of facts, the NDA, Your Excellencies, was only to be applied on matters concerning the work in the development of a vaccine. However, in this case, Your Excellencies, the disclosure of Ms. Kaimblat Formoon is one that is not related to her work, but to the health, the safety, and the welfare of those found in the NDL and the Siguro province. This is, in fact, a well-founded fear, triggering complementary protection. On the second note, Your Excellencies, with regard to non-state actors, we wish to clarify, we are not omitting state practice. What we are saying, Your Excellencies, is that there is varied state practice, and the decision of this court in the armed activities in territory of Congo still stands. Before the applicant state could make such declaration, it should declare that it is custom under international law. And in order for it to be custom, state practice must not just be varied. In fact, it should be widespread and uniform, coupled with opinio juris sive necessitatis. And the applicant did not prove that in this case, much less an armed attack. Your Excellencies, this ends the rebuttal of the respondent. Thank you, and may it please the court.
Thank you very much. That concludes the hearing. I don't know if the bailiff has to say something now, or in any event, we retire to consider our decision.
The Honorable Court is now adjourned. The judges will now exit the courtroom to deliberate and will inform the parties when they are ready to return to the courtroom to provide feedback.
I think we as judges have to go to the judges' preparatory room.
I think everyone is here. Yes. So before announcing the result, we're each going to say just a very few words. Please.
Well, thank you very much. It was a great privilege to judge both teams. My name is Anthony Casamatis. I've been coaching Jessup Moot teams. I teach international law, and I've been coaching Jessup Moot teams for over 20 years. Having taught, I'm not going to give any sort of feedback in terms of advocacy. I just want to say something briefly about participation. I've seen over those 20 years careers blossom through the Jessup, and I've had students who've participated who have gone on to be advocates before the International Court of Justice. Having also coached for 20 years, I've seen teams that have been knocked out in the preliminary rounds in Australia or knocked out in the preliminary rounds in Washington, and I've seen teams that have gone on to success. And I just want to say that I actually don't think that the benefits to be derived from the competition are in any way dependent on the final rankings. The team that doesn't progress, it's a very empty feeling being knocked out, but it goes really quickly, and the benefits of participation will long outlast the emptiness that you feel in terms of the ultimate outcome. And the particular former student who I mentioned before, who's appeared on numerous occasions before the International Court of Justice for multiple states, her team didn't make it to Washington. Her team was knocked out at a quarterfinal in the Australian rounds, and so that just underlines, I think, so I'd just like to congratulate both teams and offer my commiserations if the team doesn't progress, but just assure you that that it ultimately doesn't matter. So, thank you.
Thank you.
Well,
Mclennan.
let me follow on from that. My name is Jackie Mclennan. I'm a partner in White & Case, and I focus very much on international trade law and antitrust law, and my practice has international law built into it from those two perspectives. I studied public international law very many years ago, and unfortunately, I did not take part in the Jessup, something I deeply regret. I did not know of the Jessup's existence at that time. However, because of my partnership with White & Case, I've been part of the Jessup for many years now. And I'm struck by what Anthony has just said. It absolutely is not a question of being the winner. The Jessup is a competition that really gives you so much that you can found upon no matter what you do in your future, that it is a competition you will never, ever forget. It's hard to believe that people who have hair that is grey and lines on their face will have strong memories of what happened at a particular moment in their life 30 or 40 years before. But I can tell you that your experiences in this competition will stay with you. And we in White & Case had a small event where we were fielding many of our alumni from the Jessup competition, and the memories that were strong were from individuals whose teams had not necessarily progressed to Washington, and certainly had not won. But what they took from their the legal skills that they had gained, the skills of confidence, the skills of being able to stand on one's feet and speak clearly and coherently, and at least give the impression of being in a good position in the law, even when you know you're not quite standing on strong firmament, is something which is very valuable. So I do commend all of your performances today. It's been a delight to be part of this. It's always very hard to make a decision, but a decision has to be made. And with that, I will pass to Sir Michael.
Well, thank you. I don't know who you're referring to with the grey hair and the lines.
Me.
I mean, let me take the opportunity, as others will, I'm sure, to thank White & Case very much for their support for the Jessup over so many years. It's really tremendous, and everyone, I think, is very grateful. Well, my name is Michael Wood, and I was a legal advisor in the British Foreign Office for some 35 years. And after that, I spent the last 10 or 15 years as a lawyer in private practice, mainly acting for states in international courts and tribunals, including the International Court of Justice. I'd just like to say about the Jessup that when I was in the Foreign Office hiring people, when it came to looking at the CVs and deciding who to interview, I was always impressed if it said that the person concerned had participated in the Jessup moot, because I knew that that meant they had some really practical experience of doing something as close as you can get to real court work, and that their knowledge of public international law would be of a practical nature, and that they would know how to argue cases in a practical way. And that always impressed me. And I have to say that quite a few of those that we eventually hired had done the Jessup moot. So I think it's a really good experience. I hope it's an enjoyable one. And it's certainly one that I think should see everyone who's participated in it throughout the competition should be of great value to them throughout their careers. So with that, all I have to do is to announce the winner of this round. And I have to get this right. I announce that the winner is the applicant. And I thank both teams very much. That's our decision. Thank you.
Thank you,
so
judges.
much.
And
And thank you to respondents. Thank you.
Congratulations to both teams.
Yeah, many congratulations to both of you.
Yes.
And I wish that we were all together, that we could be shaking hands and talking. This is a very difficult ending to a competition where your adrenaline will be flowing. So I think that we will hopefully meet at some point, some other time.
Indeed. Thank you. Well, with that, I think we conclude the proceedings. Thank you all very much. Thank you.
Thank you. And good luck to the applicants in the next stage of this competition.